Good evening, and thank you so much for joining us on The Last Word, wherever it is you're watching tonight in Kenya, around the continent, and beyond. And I must say, it always is a great pleasure to meet those of you that follow the show. A special mention I want to make tonight, I promised Zero Teach, who watches the show every other time, all the way from Kaptumo in Nandi County, and the others watching us tonight, wherever you are. Thank you so much for joining us. Always a great delight to be with you and to have your company. We have a great show lined up for you, as is always the case. Of course, today on the State of the Nation, looking at the exit of the Chief Justice Chief Justice, Dr. William Mutunga, also the President of the Supreme Court, and now we have an acting Chief Justice. We'll talk about that. My guests are already in studio, and of course the legislators as well that continue to spend time in custody. So these are the men that will be canvassing the issues we have to discuss tonight, and we want you to be part of the conversation. On our Twitter poll question tonight, we're asking you, what and how do you rank the performance of the Chief Justice? Was he successful? Was he average? Or was it a poor performance? Respond to that. Go over to KTN News Twitter handle and you'll find that poll. Let your voice count. I'll be sampling your tweets as we go along with the show tonight. The last word begins right now. All right, and of course, before we get into the main discussion tonight, we always begin with bringing you an update of our top stories today. I have done my best to deal with corruption, cartels, and apathy in the Kenyan judiciary. Those were the parting words of Dr. William Mutunga. He retired as Chief Justice and President of the Supreme Court. He stepped down on a day that also marks his 69th birthday. All right, and Kenyan Deputy Chief Justice Kalpana Rawal and suspended Supreme Court Judge Philip Tunoi are now going on retirement after the Supreme Court declined to review its earlier ruling that sent the two on immediate retirement. But the verdict has set in motion intriguing succession battles for Rawal's job and the job of outgoing Chief Justice William Mutunga. And we'll talk more about the CJ's legacy, and remember to let your voice count tonight. But in other news, the Kenyan President Uhuru Kenyatta today supported the detention and prosecution of the politicians suspected of hate speech and incitement. Uhuru said no one is above the law and vowed that as president, he would do everything in his power to ensure Kenya is free from violence. Uhuru spoke in Belgium as the Kenyan opposition leaders warned that demonstrations would resume Monday because the coalition's leaders were denied access at Pengani police station to visit detained MPs. Court leader Raila Odinga further accused the state of disrupting the IBC talks and the National Cohesion and Integration Commission (NCIC) of bias.
Members must be released without charge within the next 24 hours. And if that does not happen, there will be consequences.
Right, and Kenya's President Uhuru Kenyatta today supported the detention, as I mentioned there, of those that have been suspected of hate speech, and that's one of the stories we'll be talking about later. Let me now introduce my guest to you. Next to me tonight is Dunstan Omari, who is a lawyer. He's on my extreme left, not next to me, and next to me is Nelson Harvey as well, who's a lawyer. And we had you last night, but to continue the conversation, because we did not get to finish matters of legacy, we began that conversation last evening, but of course did not get to canvass all the points emerging and some of the areas of discussion as well. So let's kick it off with everything that has a beginning has an end. So for the CJ hanging his boots, and for many people it is a warm welcome to see, you know, an individual, a public servant at the height of their game, some would argue, actually leave, because clearly some of the intrigues we saw unfolding at the judiciary were people refusing to leave when the law says one thing. And you gave your ranking, saying on a score of 9 to 10 when it comes to infrastructure, but 5 to 10 in terms of the judiciary. His final statements today as he stood on those case of the judiciary, the Supreme Court, what did you make of what he had to say?
Well, I think we need to give Dr. William Mutunga a little bit of more credit. He did not overstay his welcome. I think the culture in Kenya and many developing countries has been leaders are always forced to go home. But Mutunga has demonstrated that when you've done your bit, you may as well go home freely without being told to go home. So to that extent, I think we need to give him a lot of credit.
Okay. And your thoughts, Dunstan?
Well, I do find that the retired Chief Justice, as my learned seniors clearly put it, in Africa we have the Nkurunziza, the Mugabean, the Musevenian approach where people cling to power. He had that option in this case of Rawala and Tunui to say that retirement age is 74, which could have extended his years as a Chief Justice because he could still be working. So on that, I give also him credit. Two, I do find him to have, he might not have done very well because there was no benchmark for him to be compared with. The old CJs had nothing to offer. It was a total sham because remember, retired Chief Justice comes to power in 2011 when Judiciary was an extension of the executive.
Right.
So really, there is no benchmark to compare him with. It is the same approach of the Kibaki regime. Kibaki regime came, whichever small he did looked to be monumental because the 24 years of President Moi was seen by historians to have been a total disaster and nothing was there. Therefore, whatever small that the Chief Justice has done, we'll appreciate that there was no base, he had no infrastructure, he had no finance, he had no benchmark.
But there's still something to compare with because the judiciary had its own then historical injustices, if you like, in as far as infrastructure breakdown. He even talked about when he addressed the Senate how the Supreme Court now then was stinking and it was filthy.
So that is why we say he's done tremendously well, considering that he came from zero, negative, to come to ground zero, then from ground zero, start development.
Right.
To me, he's done tremendously well. Out of 10, I'll give him 9, because he really worked from nowhere. Creating infrastructures, starting from negatives. Remember, the executive really rejected whatever that the judiciary wanted to do. He was fighting serious battles of the cartels, as my friend calls them, of the executive that was getting a new lease, a new person, a new sheriff in town who was bringing new changes. He was also fighting from the insiders of the judiciary who thought that it was their entitlement to rise from a magistrate to the Chief Justice. So really the battle was tough, but he survived the battle. He's left something on which anybody who comes in, it's not easy to go back.
Yeah.
The options of going back and clawing back the gains are not there.
Are not there. The state at which he leaves, especially the Supreme Court, is that a blot in his legacy, Harvey?
I think it is a big blot in his legacy because Mutunga has demonstrated at the tail end of his tenure his inability to make a decision. And the most fundamental role that a judge is bestowed both by the natural consequences of doing justice and the Constitution is to make a decision. Now, it is quite apparent that when the Supreme Court had an opportunity of determining for once and for all the age of retirement for judges, Mutunga shied away from making that decision. And much as him and two other judges may claim there was conflict and bias that necessitated their inability to decide this issue, I do not think that is a justified answer. Reason being, a judge is supposed to rise above their own personal prejudices and make a decision. So it would have been much better if we knew, as at the end of day yesterday, that judges retire at 70 in respect to the judges who were hired during the tenure of the new constitution, or judges retire at 74 for those who were hired much earlier. I don't think that was a very big decision that Mutunga could not have made.
But did it just depend on him? Because it was a matter that was being canvassed through the courts for the past 2 years, in as
Yes.
far as especially Judge Tuno is concerned, because he's now 72.
Yes.
So it's a matter that has been in the system. There's been multiple applications and all that has kept the matter alive. So could he have then subverted the same justice he's supposed to be protecting and say, hey, this is what I think?
I do not think he could have subverted the course of justice, reason being that the Supreme Court is the apex court.
Right.
The decisions of the Supreme Court are not based on factual considerations. They are technical considerations on issues that may appear to be very controversial, but for which a judge properly guided can come to a proper conclusion as to what is the operative law and to what extent does it operate.
Right.
And in my view, whether it is 74 or 70 was an issue that anybody properly guided on the law will have made a decision on. I think he just shied.
Yeah.
Yes.
And in his address, Dunstan, to the Senate the day before yesterday, he addressed the matter of activism, because there's largely at some point we saw critics say that the judiciary had turned into an activist judiciary, and he went on to say what is conservative, judiciary, and even our constitution in of itself was one that was largely activist in nature. Do you agree with those kind of sentiments?
I do agree with him totally, because law is in motion. Law is not static. The law is supposed to follow the changes and dynamism of the society it is supposed to serve. So Mutunga seems to be moving with the direction the public, the citizens are moving. The Constitution of Kenya and very many constitutions worldwide are not dead appendages. They are living constitutions. The American Constitution, that is over 200 years, is still serving the American people, because in its interpretation, it must move with the times of the Americans, and therefore the Kenyan Constitution, that is only 5 years, must also be interpreted in a manner that conforms with the actual situation that is there today. Therefore, that Constitution, in whatever that looks unconstitutional now, in 100 years' time, it will be constitutional. That's the difference between a constitution and a statute. So in his own words, he is telling people that accept the station, the bus stop where now we are. We started at Kayole, now we are at Kisumu.
Yes.
And therefore we must look at things from where we are. Let us not be looking at things the way we looked at them in 1963. And that was the advice you're saying, that as people call it activism, to him, it is re-engineering, that society is re-engineering itself, society is accepting new norms. What was not acceptable is now part and parcel of the Kenyan culture. That constitution must provide for those innovations. Creativity and in being innovation is part of constitutionalism.
Right.
So long as the majority agree to that movement. Remember, if you look at the Supreme Court, it is supposed to deal with doctrinal issues. Doctrinal issues are issues that really deal with public interest matters. The public interest matter in 1970 cannot be the same public interest in the year 2017. So as we continue moving, the Constitution must continue to live with that. And therefore, that is why it is very suicidal to have very conservative judges at the Supreme Court, because that is the apex court that once it has pronounced itself,
That's it.
it is a finality. We
Okay.
must have progressive judges who will have to move with the times as they come.
And we now have an acting Chief Justice, Justice of the Supreme Court, Mohammed Ibrahim. We'll talk about that shortly and listen to a clip as well on the same. But before we leave the matter of Justice Mutunga, his new assignment, if you like, representative of the Commonwealth to the Maldives, is this a natural progression when you've been a CJ? Is it the next big thing to become a representative of the Commonwealth? Javi?
Well, I don't think it is the next big thing because the Maldives is such a small country. Well, it reminds me of those senior government officials who, upon retirement, will be appointed ambassador in a nondescript West African country. But let's give him an opportunity to exercise his diplomatic skills. Perhaps he may end up being a very good ambassador.
What
for the
does it
Commonwealth.
entail, actually?
Well, it entails propagating the ideas and the policies of the Commonwealth. And essentially, he will be the face of the Commonwealth in that island called Maldives.
Okay,
Yes.
so you don't see it as the next big thing. My director, if you please play for us that clip of Mutunga's successor, even as we talk about the man who's now, at least in the interim, at the helm of the judiciary. And also, we're receiving your feedback, which I'll be reading in just a bit, on what you think of Mutunga's performance. Was it successful? Was it average? Or was it poor? Keep your thoughts coming at Sophia Wanuna is where you can tweet me.
Honorable Justice Mohammed Ibrahim will preside the Supreme Court pursuant to Section 6, subsection 2 of the Supreme Court Act. The Court of Appeal will be overseen by the President of that court, Honorable Justice Paul Kiara Kariuki. Ibrahim is here, and the High Court will be under the leadership of the Principal Judge of the High Court, who is here, Honorable Justice Richard Mongo. The Chief Registrar of the Judiciary, who is the Administrative and Accounting Officer of the Judiciary, Ms. Anna Madi, is here, remains in charge as the Accounting Officer and the Chief Administrator of the Judiciary. This team constitutes the Judiciary Leadership Advisory Council and will offer directions on the operations of each court.
All right, so the man we'll be seeing leading the judiciary at least until we have a substantive Chief Justice following recruitment exercise is Judge Mohammed Ibrahim. Your thoughts on him?
Well, first and foremost, Judge Mohammed Ibrahim is the senior-most judge. And in our profession as lawyers, seniority is very, very critical. So, by virtue that there was no sitting deputy CJ, then Mohammed takes that.
And
On
seniority is based on number of years or what?
Seniority is based on the day you are admitted as an advocate.
Right.
When is it you became an advocate? So whoever signed the role of advocate earlier than you becomes your senior, and you'll always respect him or her. That is how Mohammed gets that position. I hear it is also applicable in the police force and all over, that in case of any vacuum, whoever is senior takes that position. Mohammed comes to that position in a very, very interesting scenario. There were complaints that were launched that there were judgments that he had never delivered for quite some time. And actually the Chief Justice bent backward to allow Mohammed proceed on some leave to complete those judgments. So the question among the lawyers is he a very competent judge if that was an allegation that was there? Two, Mohammed Ibrahim, at one time, there is rumor they were part of the judges that went on strike. So is he really likely to move out of that perception that he's there? Three, the last issue that is there is, what is his age? Is he likely to be part of the people who are going to contest to have this job? So those three scenarios makes his tenure quite emotive in terms of when we look at, is he likely to contest to be a CJ? We have seen anybody who gets an acting position, always stands a better chance to manipulate issues for him to be there. But of great concern for the citizens, he does not sit at the at the Judicial Service Commission.
But
Is
is he
he
by
now
virtue-
going to be
Yeah.
a member of the Judicial Service Commission by pursuant to him being an acting Chief Justice? So there will be two people sitting in the JSC, him and Professor and Dr. Smokin Wanjala.
Wanjala.
Do they have aspirations to contest? Will it be fair and just for people who will receive applications to shortlist the candidates and also sit in the panel? Will it be fair? Remember, the two of them disqualified themselves
And perhaps they'll do the same thing.
because of those other guys are their colleagues.
Right.
Justice Tunui and Justice
conflict
Rawal.
of interest.
So are they going to have conflict of interest and say, we now move away from JSC because we have an interest in this job
This-
coming?
Yeah, and Happy, I'd love to hear your thoughts on the same, but also to remember that in 2012, the Judges and Magistrates Vetting Board had actually found Justice Ibrahim unfit to serve in the judiciary.
Yes.
However, he appealed the same, saying that one of the members was biased towards him, and in fact, he relied on an SMS that then he went to appeal, and he said he relied on an SMS allegedly sent by a member of the interviewing panel on 22nd July to some lawyers, and it read, and I quote, "I am shocked Eldoret lawyers do not think we should have sent Ibrahim Mohammed packing despite the delay. If one cooks and cooks food and never serves for eating, how could you say he's a good cook?" So this allegedly was sent by one of the panelists in the interview. So of course, the individual recused themselves, or they were made to sit out to the next round of vetting, and then that initial decision was reversed. Does that have any bearing with him now, and even going forward if he does seek the job of CJ?
Well, let me address it in three perspectives.
Right.
I think first and foremost, there is a big failure in the succession of Mutunga. Mutunga has paraded those three individuals, Justice Mohammed Ibrahim, as the presiding judge of the Supreme Court. He has also paraded Justice Kariuki Kihara as the president of the Court of Appeal, rightfully so. And he has also paraded Anne Amadi as the chief registrar. Yes, and Justice Richard Wongo as the president of the presiding judge of the High Court. Now, one issue that does not come out quite clear, and for which there may be a misconception, is this: there is no acting Chief Justice, because Justice Mohammed Ibrahim can only be the presiding judge of the Supreme Court. The only other person who will have assumed the office of acting Chief Justice for a limited period of 6 months will have been the Deputy Chief Justice.
But doesn't the law and visualize and capture when those two are not, as we have the situation now, are not in office?
Now, the law as drafted has a big problem. There is a lacuna.
Okay.
So, and the lacuna is so open and clear. There is no current acting Chief Justice as we speak. And all that Justice Mohammed Ibrahim can do for now is to preside over the Supreme Court. And can he do that in the first place? The Supreme Court is deemed to be constituted with 5 judges. So far, we only have 4 judges. So they can never sit. There is no Supreme Court. So basically, for the entire duration that Justice Mohammed Ibrahim shall preside over the Supreme Court, there will be no business. So in terms of succession or transition, I think the Supreme Court has been left in a very orphaned state. Now, let's go back to the bigger role
And
of
can
the
he
chief.
sit and act at the JSC?
No, I don't think he can sit. In fact,
Okay.
it's not a matter of thinking. He can't sit at the JSC
Okay.
because the chairman of the Judicial Service Commission and the head of the Judiciary is the Chief Justice. And in his stead, then the Deputy Chief Justice can do that. So we'll have a situation whereby the JSC will have to make do without a chairman. Now, to what extent does the history of Justice Mohammed Ibrahim influence his current position? I think Justice Mohammed Ibrahim comes a long way with Dr. Willie Mutunga. When Justice Ibrahim had been vetted out, there is a public view that Dr. Mutunga went out of his way to ensure that he has a second chance. And towards that end, he even gave him an opportunity to write his decisions out of time. Now, remember also, much earlier, before the office of the Chief Justice had been declared vacant, there was an attempt by the executive then to single-handedly appoint a Chief Justice.
Yes.
Who is the judge who stopped that process? That was Justice Mohammed Ibrahim. And looking at the recent history and the body language of the judges of the Supreme Court, it's quite apparent that Justice Ibrahim, though being a judge appointed under the old constitution and who had expressed his opinion and intention to retire at 74, appears to have shifted ground and joined the camp of his other fellow two judges in the Supreme Court who thought that, notwithstanding the fact of earlier employment, then all judges must retire at 70. So it's quite clear that Justice Mohammed Ibrahim could have the same affiliations as had been held by Dr. Willie Mutunga as regards this issue.
Yeah.
Yes.
Your thoughts on what you just heard?
If I go further, I might be corrected wrong or right. I am not very sure whether Justice Mohammed was part of the political detainees that were detained with Chief Justice Mutunga at one time.
Yeah, he's one of
He
them.
is
actually.
one
Yes,
of them.
yes, yes.
So the Chief Justice for 5 years has been a political detainee. The acting Chief Justice, although as lawyers we are saying that can't be, can only be a presiding judge, is also a former political detainee. So when we look at it, are we likely to see continuity in terms of Mohammed? And remember, the Chief Justice who have just retired has a great influence on the current members of the Judicial Service Commission. So his networks will not be washed away. Is he staging managing the accession of Justice Mohammed to come there? So there is quite a lot of similarities. Even when you look at their faiths, they come from the same orientation and the same political persuasion, the same area. So there is a likelihood that Mohammed might get a chance. Remember in 1978, the then deputy president, the vice president, retired President Moy, was only given to act for 90 days. He went for 24 years. So now that he sits as the first among the equals, what is he likely to do? Remember, as my senior said, his position was very clear. It is 74. He went on strike. He put it in writing in the petition of Nick Salat that judges must retire at 74. All of a sudden, when it comes that he might be the beneficiary of age 70, he changes position. So really, we are likely to see a lot of issues in terms of that. But that not being withstanding, the next CJ, the political class will have a very serious onslaught in terms of who do they want to come. One, are we seeing a situation from the politics of the day when one judge, when one political or administrator leaves office, then the politicians from that region demand that this is our position. It is reserved for us. Remember the Olelenko issue, we went Kaisari in Kaiseri way.
Right.
When we dealt with the Kimayo in the police, we went with the Boynet
Boynet.
man. Now when we have the Chief Justice going 1 year before, are the Kamba politicians going to demand that it is their term 1 year less, so they need another CJ to take over from that?
And we have had, in fact, some of the alleged front runners being
Yes.
said if they're coming from Central and you already have the president
Yes.
and the AG, rather the Speaker of National Assembly,
Yes.
it wouldn't all go well.
So the politics have already taken shape.
Yeah.
The judge, Justice Tonui, when the first allegation came, a senator and very many politicians from his area started making noise to defend him. Tonui himself said, it is my job that is being sought by some advocates from Rift Valley who want to take my job.
All right.
So are we likely to see the question of Tonui representing Rift Valley, the question of Rawal representing the small minorities that are not among the 7 major tribes that form the Supreme Court, demanding that this is our slot,
Yes.
and our slot must be filled by one of the prominent sons and daughters from our region.
All
That
right.
might take the day.
That might take the day. And Javi, I want to hear if you think those issues that should influence the JSC as they conduct the interviews. But let me read some of your feedback tonight. Alois Ngaga, you say, play for us the video of CJ during the announcement of the 2013 presidential election petition. Legacy is questionable. That's your thought. The Kabebera, you say, you will have another Chief Justice and 2 new Supreme Court judges come 2017. So we should, in essence, not worry. Meshach Osachi, wise and good example than trying to challenge Supreme Court for additional years in the office, is what you think of the CJ outgoing, okay, gone, not outgoing. Safina Makungu, I remember when he wanted the seat, our DP said that he was a devil worshipper since he wore earrings. All right, COG, you say must be a Kenny Rogers fan. He's a great gambler. He knew when to run. He shall be missed. Stephen Wanda, you say he did a lot, but 2013 presidential petition will haunt him and his tenure. And more of your views. And clearly, many people remembering that earring debacle, especially during his vetting. But Javi, before we move on, because I want us in the next few minutes to talk about also another big story we've been following in terms of the JSC as they now seek to recruit. They've already put out ads.
Yes.
You know, for the Deputy CJ, CJ as well. The Tenori Tribunal, perhaps we expect that now they'll come and say work is done, but tell us your thoughts on that. What is it you expect to see now from the Judicial Service Commission in this recruitment exercise?
I think the Constitution and the Act have set out very elaborate mechanisms upon which the Judicial Service Commission will be guided in recruiting a Chief Justice and a Deputy Chief Justice. So to that extent, parochial ethnical interests that have permeated the replacement of other big office holders in government may not be a big factor in the recruitment of the replacement for Dr. Mutunga or for Justice Kalpana Rawal. Now, but that does not mean there are no interests in that process.
Right.
In fact, this is one office where if you are to determine the key interested parties, you'll find these fellows do not have any ethnic affiliation.
Right.
It is a group that we have actually called the cartel. You'll find many of them conglomerating together, irrespective of their geographical or ethnical background. And throughout the tenure of Justice Willie Mutunga, there has been a big power vacuum that this cartel came in to fill. And we cannot say with certainty that they will not want to do the same thing. And that is attributable for one virtue that ended up being the vice of Dr. Willie Mutunga. Dr. Willie Mutunga was really averse to power. He didn't want to be in control of many things. And as a result of that, many people who wanted to control issues at the Judicial Service Commission came in. And they did so at the most initial stage. 6 months before this office was advertised, a key member of that interest group, whom we have now called the Grand Mullah, Nasir Abdullahi, actually indicated this is the most qualified candidate for me. And there is no denying, there is a big relationship between Nasir Abdullahi, Paul Mwite, and also Justice Mohammed Ibrahim. Justice Mohammed Ibrahim was for a long time a partner of Paul Mwite when they were in practice. And if you look at the decision by Justice Mohammed Ibrahim, he clearly demonstrates that he's one person that can be swayed by things of this kind. Because at one point in time in his decision, he said clearly, when I wrote the memoranda indicating that judges must retire at 74, little did I know that the matter would become justiciable and end up in the Supreme Court. Now, under the Constitution, a judge is supposed to be an individual of high moral character, high integrity, and impartial.
And judges are allowed to change their minds.
No, they are allowed to change their minds, but
He'd argue that's what happened.
I believe that's what he will argue. But you see, when a judge expresses his mind in pen and paper, more often than not, it becomes law.
Okay.
Yes, and you are entitled to change your mind for good reason. But from what we saw the day before yesterday,
Yes.
there were no good reasons as to why he changed his mind.
Yeah.
And there is a big fear that in the process for the recruitment of Mutunga's replacement, these interests may come again to feature and may want to fill the void that was there during Mutunga's tenure, which we can clearly say may be there for the entire duration of 6 months.
Okay.
That will be waiting for another Chief Justice.
That will be waiting. All right, stay with us here on The Last Word on KTN News. Glad that you're watching tonight. We want to take a short break. When we return, we'll get to matters hate speech. We heard from CORD leader Raila Odinga on that ultimatum. If the detained MPs affiliated to CORD are not released in 24 hours, then they will be taken to the streets. And also President Uhuru Kenyatta, who's in Belgium, had say and weighed in on the matter as well. So stay with us. We'll continue the conversation here after the break.
This is KTN News. This is KTN News.
That hate speech and insightful statements cannot and will not be allowed. Statements that incite communities against each other, statements that incite Kenyans against each other, statements that instill fear or hate between communities will not be allowed. And my position is that those statements, be they coming from CORD, be they be coming from Jubilee, be they be coming from whoever, will not and shall not be entertained, and those who choose to walk that path will face the full force of the law. And that has been my position. It's not something new. I have stated it severally, and that shall be the way it will be, so long as I am president.
All right, President Uhuru Kenyatta there in Belgium speaking about the question of hate speech that has also dominated the news headlines. My guest tonight, Dunstan Omari, who's a lawyer, and Nelson Harvey as well with us. Gentlemen, do you find that these matters of hate speech are overly politicized in the country? Dunstan, I'll begin with you. Because it appears to, especially when it comes to politicians, largely they will go for, Team A will be like, okay, they're targeting us. Team B will be like, we're being targeted. It's always about that, not the merit or the merits of the issues at hand.
First and foremost, Sophia, I'll have to declare on live TV that one of the people arrested, Honorable Senator Mudhama, is my client. Honorable Kimani Ngujiri is a personal friend. We do a lot of talk shows with him. I also represent him on other matters. And Honorable Ferdinand Waititu is also a good friend of mine and a classmate in Form 2. So those are 3 friends of mine who are locked inside. But the basis of my position is this. Hate speech is a very serious offense. And hate speech can bring genocide in a country. It's not one of those cases that a state can joke around with, especially in light of 2017. The problem that is there is the manner in which it is handled. Sophia, when you look at the Constitution, Article 49, 1F and 1G, when Jiku and I and everybody passed a constitution that says that the police, if they arrest, they are supposed to arraign somebody in court within 24 hours. That is Article 49, 1F. In Article 49, 1G, it goes further to say that if that 24 hours, the police have any reason to want to detain that person for long, they'll move to a court of law, declare to the court of law, when the suspects are in court, on why the reasons, they provide the reasons as to why they want to detain these people. The Constitution in Article 49, 1G does not specify for how long. That is exactly what happened when the suspects were taken to court. They were not charged. Remember, they have not taken a plea. They were only informed of why the state wants to detain them. And the reason was that they want to do more investigations. They were arrested before the investigations were complete. And the magistrate allowed the police to keep them for 4 days. They went to the High Court, and the High Court refused and said that those reasons will be provided. I'm sorry, I have not been able to get the reasons why Justice Onguto did give that. Once I get them, I'll be able to comment. Right. So within the law, the state has those parameters at its disposal. 3, under the Protection of Terrorism Act, Section 33, it provides that if somebody is charged under or suspected to have been charged, to be charged under that provision of Section 33, he can be detained with the similar provisions for 30 days. Upon the expiry of 30 days, the state can again come and request for another 365 days within the police station. But the mentions shall be after every 30 days. So the question that is there, are the suspects likely to be charged under that? Do the utterances they made fall under the provisions of terrorism? No. There's grounds that they might be charged are for hate speech. Hate speech must involve a tribal element. Ethnicity is very critical.
Okay.
When you peruse through what they said, there is nowhere ethnic animosity was mentioned. So really, I do not know for what offense they will be charged they'll be charged.
So, Harvey, do you agree with Dunstan that there is perhaps a subversion of the law here, or is it a court that is also keen to send a strong message and take a position, because largely we've seen many people criticize these processes and say these people go to court and nothing much seems to happen?
I think I will agree to a great extent with my learned colleague as to the legal provision that governs the issue of hate speech, confinement, arraignment, and trial. But let me also emphasize one key issue that many Kenyans may want to brush aside. I think the responsibility of guaranteeing security, peace, lies with the executive. And of late, we have seen very serious lamentations from the president and other senior government officials as to their inability to rein in and tame this issue of hate speech. Largely because when these issues are brought to the courts, the suspects are not given stiff penalties, and even when they await their trials, the mechanisms that have been put by the court to contain the actions of these individuals are not sufficient. Now, with that background, permit me to refer to a very famous verse in the national anthem. May we live in peace, unity, and liberty. Now, Kenyans must learn to coexist in unity. Kenyans must learn to live in peace. And Kenyans must learn that those two are prerequisites to liberty. So that if an individual interferes with the peace and unity of other individuals, there may be justifiable reasons as to why the state may want to crack the whip and take stern measures, as we have seen in respect of these honorable members of parliament and the Senate. So to that extent, the key issue needs to be understood within the confines of the predicament that the state, as the custodian of our liberty and peace, finds itself vis-a-vis the actions of these honorable members of parliament and the Senate, and the inability for the judiciary to provide fast remedial solutions to the problem.
Yes,
Yes.
because now we have an ultimatum, 24 hours, given by court leader Raila Odinga. They're anyway supposed to be in custody for 4 days.
4 days.
And that expires tomorrow.
Yes.
So anyway, 24 hours will lapse equally at the same time.
Yes.
But isn't it, and you'll hear from many Kenyans, even from the feedback coming through, is that it gets to a point that it just looks like political machinations and just playing, back and forth, when it's all about, again, back to what I was talking about before, my guy, my person, this and the other, targeting us or the other. Do you not agree that there's substance in saying that largely we've seen impunity when it comes to hate speech, and that's why it continues to thrive, and yet the dangers and how deep it could take us as a country are so grave?
Well, the issue that is becoming of great concern is not the duration they have been kept within the police station. That is provided, as I've said, pursuant to Article 49, 1G. The question is, did the magistrate provide specific orders restricting their families from visiting them? Did the magistrate give orders specific to the effect that friends and colleagues and other people cannot visit them? They were not given, because the Bill of Rights provides that they are mere suspects. The law and the police standing orders are very clear that once your relative has been arrested, you have a right to access to him. Counsels, lawyers have a right to access to them. I am aware that there were lawyers, there were counsels who went and they were denied access to their clients, one of them being Harrison Kinyanjui. I did go to Pangani. Luckily, I was allowed to access my clients. I did talk to them, got instructions. So the question that is there is the manner in which the police are simply excited to cause what is purely legal. Now Raila is turning it to be a political contestation. And to that advantage, he is now giving ultimatums based that they must be released and not be charged. There is no provision under the law that Raila is quoting to say that people must be released without being charged. That is only the mandate of the Director of Public Prosecution. He is only the person, after the police have finished their investigations, they will forward the file to the DPP. The DPP will make up his mind to charge or not to charge. Therefore, these ultimatums are purely political. And the police have always said in this live show, every other time, they sometimes do not know the repercussions of the decisions they take. Because right now, we are heading again out of the denial of basic fundamental rights of suspects to access their families, to talk to them, to talk to their lawyers.
Right.
It is now we are saying, let us go to the streets.
So, because you've talked about politicization of the same, and Emmanuel Talam, who's the Director of Communications at the Office of the Deputy President, earlier tweeted, the ultimatum by court to the state to release hate speech suspects confirms everyone's fears that court thrives in anarchy, not respect of the law. So we have about 3 minutes to go as we wind up the show. So Harvey, as you talk about that, I know that you agree with those sentiments. Also address the question of hate speech, because NCIC agrees in terms of the law